All right. Anything else? All right, I'm ready to read the instructions. All right, ladies and gentlemen of the jury, you have found both Damien Echols and Jason Baldwin guilty of capital murder. After hearing additional arguments of the counsel, and I'm going to limit their arguments to 20 minutes unless anybody has any strong objection. I'm not going to keep a direct clock. It'll be loose. But I'd ask you to confine your arguments to within that time frame if possible. If you need an additional 2 or 3 minutes, fine. You will then again retire to deliberate and decide whether they are to be sentenced to death by lethal injection or to life imprisonment without parole. In determining which sentence shall be imposed, you may be required to make specific written findings as to the existence or absence of aggravating or mitigating circumstances. Appropriate forms will be provided for you, and I will now instruct you on the procedures that you must follow. There are 3 forms for each count, that is, similar to your previous verdicts, for you to use in reaching your decisions, and a verdict form for you to use when your verdict has been reached on each of the 3 counts for each of the defendants. Form 1, which will be handed to you later, deals with aggravating circumstances. The appearance of any particular aggravating circumstance on the form does not mean that it actually existed in this case. These are specified by law and are the only aggravating circumstances that you may consider. The state has the burden of proving beyond a reasonable doubt that one or more of the listed aggravating circumstances existed at the time of the commission of the capital murders. If you find unanimously and beyond a reasonable doubt that one or more of these aggravating circumstances existed, then you will indicate your findings by checking the appropriate space on Form 1. If you do not unanimously find beyond a reasonable doubt the existence of any aggravating circumstances, then you will cease deliberations and indicate on the verdict form a sentence of life without parole. If you do unanimously find one or more aggravating circumstances, gentlemen, there's only one, so only one is listed. If you do find one aggravating circumstance, you should then complete Form 2, which deals with mitigating circumstances. Form 2 lists some factors that you may consider as mitigating circumstances. However, you are not limited to this list. You may, in your discretion, find other mitigating circumstances. Unlike an aggravating circumstance, you are not required to be convinced of the existence of a mitigating circumstance beyond a reasonable doubt. A mitigating circumstance is shown if you believe from the evidence that it probably existed. Form 2 is made up of 4 parts. Part A is a list of mitigating circumstances to be checked only if you unanimously agree upon a particular circumstance existed. Part B is a list to be checked where some of you think a circumstance existed, but all do not agree. Part C is a list to reflect circumstances of which there may have been some evidence, but no member of the jury feels that the circumstance existed. The last part, D, is to be checked only if the jury concludes that there is no evidence of mitigating circumstances. After making the determinations required to complete Form 1 and Form 2, if applicable, you will then complete Form 3. In no event will you return a verdict imposing the death penalty unless you unanimously make 3 particular written findings on Form 3. These are: first, that one or more aggravating circumstance existed beyond a reasonable doubt. Second, that such aggravating circumstances or circumstance outweighs beyond a reasonable doubt any mitigating circumstances found to exist. And third, that the aggravating circumstances justify beyond a reasonable doubt the sentence of death. If you make those findings, you will impose the death penalty. Otherwise, you will sentence the defendant to life imprisonment without parole. After you have made your determinations on Forms 1 and 2 and have reflected your conclusions on Form 3, then you must check the appropriate verdict on Form 4. Each of you must sign the verdict form. You may now strike that. I'm going to read one set of the 4 forms. And you must remember that there are 6 sets of these forms dealing with each count and 1 for each, 3 for each of the 2 defendants. And they should be considered by you as separate verdicts as to each defendant. All right, Form 1 reads as follows. We, the jury, after careful deliberation, have unanimously determined that the following aggravating circumstances or circumstances existed beyond a reasonable doubt at the time of the commission of the capital murder. The statement is the murder of one of the victims committed by one of the defendants was committed in an especially cruel or depraved manner, with appropriate place for you to check should that be your unanimous finding, and a signature space for the foreman to sign if it is a unanimous finding. For definition purposes, cruel manner is defined by law. A capital murder is committed in an especially cruel manner when, as a part of a course of conduct intended to inflict mental anguish, serious physical abuse or torture upon the victim prior to the victim's death, mental anguish, serious physical abuse, or torture is inflicted. Mental anguish is defined as the victim's uncertainty as to his ultimate fate. Serious physical abuse is defined as physical abuse that creates a substantial risk of death or that causes protracted impairment of health or loss or protracted impairment of the function of any bodily member or organ. Torture is defined as the infliction of extreme physical pain for a prolonged period of time prior to the victim's death. Depraved manner is defined. A capital murder is committed in an especially depraved manner when the person relishes the murder, evidencing debasement or perversion, or shows an indifference to the suffering of the victim as evidences a sense of pleasure in committing the murder. Form number 2, mitigating circumstances, Part A. The first option, we unanimously find in regard to one of the defendants that the following mitigating circumstances probably existed at the time of the murder. And you're indicated that you should check applicable circumstances and specify any additional ones not listed in the space provided. And those mitigating circumstances in Part A are the capital murder was committed while one of the defendants was under extreme mental or emotional disturbance. The capital murder was committed while one of the defendants was acting under unusual pressures or influences or under the dominion of another person. The capital murder was committed while the capacity of the defendant to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of law was impaired as a result of mental disease or defect, intoxication, or drug abuse. The youth of the defendant at the time of the commission of the capital murder. The capital murder was committed by another person and the defendant was an accomplice and his participation relatively minor. The defendant has no significant history of prior criminal activity, and then other, and you are to specify any other mitigating factors that you unanimously find in Part A. Part B, one or more of the members of the jury believe that the following mitigating circumstances probably existed, but the jury did not unanimously agree. Those options are the capital murder was committed while the defendant was under extreme mental or emotional disturbance. The capital murder was committed while the defendant was acting under unusual pressures or influences or under the dominion of another person. The capital murder was committed while the capacity of the defendant to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of law was impaired as a result of mental disease or defect, intoxication, or drug abuse. The youth of the defendant at the time of the commission of the capital murder. The capital murder was committed by another person, and the defendant was an accomplice, and his participation relatively minor. The defendant has no significant history of prior criminal activity or other. Part C has the exact same statements that is prefaced as follows. There was evidence of the following mitigating circumstances, but the jury unanimously agreed that they did not exist at the time of the murder. And then you would make the appropriate checks on the exact same statements or any other mitigating factor that you choose to consider. And that should be written in the space provided. Part D, there was no evidence of any mitigating circumstances, and you're to check that if appropriate, and the foreman would sign in the place provided on Form 2. Form 3, and again you're reminded that there are 6 forms, 1 representing each victim and 3 for each defendant, reads as follows. The jury, having reached its final conclusions, will so indicate by having its foreman place a check mark in the appropriate space or spaces in accordance with the jury's findings. In order to check any space, your conclusions must be unanimous. The foreman of the jury will then sign at the end of this form. It further reads, we the jury conclude, A, 1 or more aggravating circumstance did exist beyond a reasonable doubt at the time of the commission of the capital murder. There are instructory comments following that. It says, if you do not unanimously agree to check paragraph A, then skip B and C, and sentence Damien, strike that, the defendant, to life imprisonment without parole on Form 4. Paragraph B, the aggravating circumstances outweigh beyond a reasonable doubt any mitigating circumstances. You're then instructed by the following paragraph, if you do not unanimously agree to check paragraph B, then skip C and sentence the defendant to life imprisonment without parole on Form 4. Paragraph C, the aggravating circumstances justify beyond a reasonable doubt a sentence of death. An instructory paragraph follows. If you do not unanimously agree to check paragraph C, then sentence the defendant to life imprisonment without parole on Form 4. The conclusory paragraph, if you have checked paragraphs A, B, and C, then sentence the defendant to death by lethal injection on Form 4. Otherwise, sentence the defendant to life imprisonment without parole on Form 4. And again, the jury foreman is to sign where provided on Form 3. Form number 4 is the verdict form. And you've been given previous instructions by Forms 1, 2, and 3. It reads as follows. We, the jury, after careful deliberation, have determined that the defendant shall be sentenced to 2 options, A, life imprisonment without parole, B, death by lethal injection, and it indicates that each juror, and there are 12 spaces provided on the verdict form 4, must sign in the area provided. That is, all 12 of you must agree and sign. Are there any questions? Gentlemen, anything additional? All right, ladies and gentlemen, you may now, I'm going to hand these to you in 2 packets. Yes? I'm sorry, argument. Yeah, okay. I knew I was trying to skip something. All right, you may argue your case. How do you want to break it up? You want to use the full 20 minutes, or are you going to use a part of the time and reserve some of it?
It's going to be real short.
All right.
Please, the court, ladies and gentlemen of the jury, as I told the court, I'm going to be short, and from my prior arguments, y'all may not think that I'm capable of that, but it will be. Y'all have heard everything, and there's not a lot more to say that you can say. It's extremely important in this case that when you go back and look at those instructions, that you, just like the judges told you all along, that you consider each victim separately and each defendant separately. And when you consider those verdicts and you decide whether or not the murders occurred in a cruel or depraved manner, it is crucial that you consider each victim separately and each defendant separately and decide for each of these victims whether or not their death meets that definition. And it's crucial that you do that. As far as whether it meets those definitions, for each one, words can't describe. I was going to show you the pictures again, but I'm not going to do it because y'all seen the pictures and you know what they are. But again, I urge you to look at each one of them separately. This case depends on you looking at each one separately. If for some reason you decide that one of the deaths does not meet the definition, make the appropriate verdict for that particular victim. Now, in this case, these records were introduced, and I want to remind you what the judge told you. This stuff, this Dr. Moneypenny's testimony and the questions that I asked related to Damien Echols' statements, they only apply to Damien. Only. They do not apply to Jason Baldwin. The testimony, they said, well, Damien wouldn't have an opportunity to be with his son. Ladies and gentlemen, Michael Moore and Stevie Branch and Christopher Byers, their families can't be with them anymore, and they can't be with their families. That was taken away from them on May the 5th, 1993. I told you I wasn't going to talk long. I'm not. I'm going to conclude with this. This statement of Damien, he puts it all in, I just put it all inside, describes this as more than just anger, like rage. Sometimes he does, in quotes, blow up. Relates that when this happens, the only solution is to hurt someone. Damien reports being told at the hospital that he could be another Charles Manson or Ted Bundy. When questioned on his feelings, he states, I know I'm going to influence the world. People will remember me. We ask for your verdict.
Ladies and gentlemen, this is a very difficult thing for me, because I've been here for a month advocating a different position. But a long time ago, when I went to law school, I believed in the system, and I respect your verdict. But I would ask that you listen to me at this time as I plead for my client's life. I've made my arguments, and I've advanced my beliefs and my theories. And the prosecutor has advanced his beliefs and his theories. And in your deliberations, you chose to believe the facts as presented from his perspective and his beliefs. And so now I want to remind you of his beliefs and his perspectives. And I'd like for you to realize those things as you look at Form 2, which deals with those mitigating circumstances. There are 6 itemized mitigating circumstances. Then there is one which is left up to your best judgment on things that you may consider to be a mitigating circumstance when you determine whether or not Jason Baldwin should live or die. But of those 6 that are listed, I believe 4 of them are clearly applicable, even from the perspective of the prosecution. Number 1, Jason Baldwin has no significant history of prior criminal activity. There's been absolutely nothing told to you this young man has ever done anything before. The law allows that evidence to be presented to you at this stage of the trial, and it was not presented because there is no significant criminal history. The law says that can be considered as a mitigating circumstance, and I submit to you that there can be no other finding but that Jason has no significant criminal history, and you should so indicate on that verdict form. And I believe even the state would concede that. Number two, the youth of Jason Baldwin at the time of the commission of the capital murder. He's 16 now, and he's 16 then. I think that's what is meant by youth. And I don't believe anybody would dispute that. You can look at him, and he's a young man. I submit that even the state would agree that the capital murder was committed while Jason Baldwin was acting under unusual pressures or influence or under the domination of another person. Today's Saturday, Thursday it was when we made closing arguments. Mr. Davis said that Damien is the leader and Jason is a follower. Those were his arguments, not mine. It was their argument that in these unofficial cults, they center around one person who's the dominating force, and the others sort of do as he so directs. That was a testimony of Dr. Griffiths, and that was a position advanced by the state. So I submit to you that even the state would agree that capital murder was committed while Jason was acting under the domination of Damien. Lastly, I submit that Jason Baldwin's activity in this matter was that of an accomplice, if at all. I don't know what your deliberations were as to what activity he directly had versus what activity he may have merely aided in or attempted to aid in under the accomplice instruction. But from the evidence that I've listened to, I was unable to hear evidence that said that he was the direct participant or the direct leader, but more of an accomplice. And I believe that's consistent with the state's position in this case. Form 3 is really the form that says what your thoughts are, what your beliefs are. That one, that the aggravating circumstances did exist, and that is something you have to find beyond a reasonable doubt. And you can read that instruction and it's fairly clear. And you can decide whether or not the capital murder of each one of those boys was committed under one of those circumstances. But if you do not find that, if you do not find that the definition of especially cruel and depraved manner has been met, then sentence Jason to life imprisonment without parole. If you find that that aggravating circumstance does exist, but that the mitigating circumstances exist on Form 2 that I just discussed with you, if you find those that exist, find that they are not overwhelmed and outweighed beyond a reasonable doubt by the aggravating circumstance. Find that the mitigating circumstances outweigh the aggravating circumstances, and sentence Jason Baldwin to life imprisonment without parole. But if you find that the aggravating circumstance does outweigh those 4 mitigating circumstances, which I believe you'll find, you must then find that the aggravating circumstances so outweigh the mitigating circumstances that it justifies a sentence of death beyond a reasonable doubt. Regardless of what you find as to the aggravating circumstances, and regardless of what you find as to the mitigating circumstances, the law says you may still show mercy and give him life without parole. Your decision has already decided that Jason Baldwin will die in prison. The question is, how will he die there? I ask for mercy. Thank you.
Ladies and gentlemen, we've been here a long time, and I know that you all have gone back and you've made your decision. I don't necessarily agree with that, but I certainly respect your decision, and I respect the time that you all took to go back and to take all the evidence that you had before you and make that decision. We ask that you just give a little more time here to make this very, very important decision, that you not do anything hastily here, but that you take the time to consider this and to ponder this extra decision in your heart before making a final decision. Now, I know each of you just did everything you could to take everything into consideration when you've been back there before, and again, we ask that you do that here, that you take everything into consideration, everything that you've heard, and make those decisions. The instructions are very important, very important. The judge read them to you, but just by reading, you all can take these back there and look at them and read them and see that there are certain things on here that you can do, that the state does have a burden, and their burden is that proof beyond a reasonable doubt that we all talked about. That's on the mitigating, but then, or on the aggravating circumstances, but also if you get to the mitigating circumstances, that there does not have to be proof beyond a reasonable doubt. That's not the standard here. And we would ask that you look at those and look at these jury forms and see the check marks that you can make. See the check marks that you may find, and read the instructions and follow them as you said that you would follow the law. Let's look at briefly at some of these circumstances. One of them is youth of the defendant. We told you all about that back in voir dire, that was one of the mitigating circumstances. Probably most of you remember that. Keep that in mind as you go back there. Remember when you sat across the table from Mr. Echols? You sat across the table from Damien and you saw him. You remember his youthfulness? I mean, you're a long ways away now, but do you remember that youthfulness? But we introduced into evidence something showing when his birthday is. Think about that. Think about his youthfulness. Think about the fact that well, I know in my youth, I'm not the same person now that I was when I was 19 years old. I've made some changes. Can people not change? Is this a life that's not worth redeeming? Do people get to that point where a life isn't worth saving? Think about it, the life that he has ahead of him. That life is in you all's hands. Think about his youthfulness. That's one of the factors here. Another factor is prior criminal history. There's a place you can make a check mark on prior criminal history. And as you go back there, you will find that there is none. No prior criminal history. Nothing. No evidence. Nothing. So remember that when you make your deliberations. Now, another one is extreme mental or emotional disturbance.
very painful stuff we put on today. We didn't have to put that on, but we put it on to try to explain to you all what's going on, what this kid's been through, to try to show you what his life is like, and to try to show you the things that he's been through, and a little bit about his makeup. Think about that when you get to this part, and talk about that between yourselves. Everybody laughed at me when I said in opening arguments, I said, he's weird. I wasn't trying to cover that up. People laughed at me for saying that. He is different. That's the reason we put that on, for you to be able to see this. And to see whether or not this life can't be changed. Think about that. The doctor did testify that he felt like there could be some change. You all heard that. Another one is kind of related. It's impaired mental disease or defect, and that pretty well goes in with Dr. Moneypenny, and you all can discuss that and figure out what you think about that and how that interplays. But again, don't rush through this. Think about this. There's another place for a check mark on that. Then there is a check mark on the accomplice situation. Mr. Ford has gotten up here. He did this on closing, too, and he's gotten up here and said somehow that Jason was under the domination of Damien or whatever. There's been absolutely no testimony of that, and I think you all understand that and realize that there hadn't been any testimony to that effect. That's his argument, and the prosecutor may have even said anything, but that's not his argument. I realize from your decision, of course, that you all believe that Damien was involved in these murders. That's your decision. But even if you believe that, there's absolutely no testimony as to who did what to whom or anything. There is no testimony as to who was the most involved or the least involved. So when you think about this, Damien could be just as much an accomplice as anyone else. I mean, think about that. Think about the testimony. You all have heard the testimony. Think about what you've heard. There's a big place down here for other, and there are several different lines here. I encourage you to think of the testimony, to think what you've heard not only here today but the other testimony, and think of these mitigating circumstances. And I encourage you to write them in here. That's what the instruction says, to specify in writing. If you need other paper, put it on another piece of paper. There's just a few lines here, but put it on another piece of paper. That's perfectly fine. And put those down there, the things that you find, and write those things down. And we encourage you again to take your time in doing this. Now, when you get to the other section, I know this is a difficult thing to talk about, but we understand this was a horrible, horrible, horrible thing that happened. I mean, nobody could say anything different that's heard this. It's a horrible thing that these kids were murdered. You all looked at that stuff. You looked at the pictures. It was horrible. There's no doubt about that. But at the same time, remember the effect that that it has on the defendants also. Remember the effect that it has on Damien. His father got up there and probably said something that was more difficult than anything he's ever said in his life. You all heard that. It's having an effect on them also. I suggest to you that that's a mitigating circumstance. Think of the love that others have for Damien. Think of the love that he has for others. His son, his newborn son that he just held for the first time in the back room the other day. Don't forget these things. Think about the efforts that he's made to overcome these problems. He didn't get up there and try to hide anything. When he got up there, he told you that he'd been on medication. He told you that he'd been to the doctor to get medication. He told you that he's made efforts to help himself. He's made efforts. He knows he needs help. He goes to the doctor. He takes his medication. Consider those. Consider the fact that he's trying to help himself. I think you can also take into consideration any lingering doubt that you may have about your previous decision. I understand and respect that decision. But the decision you're making here today, it's a final decision. Is someone going to get up 5 years from now and say, what they told us wasn't right? If we put him to death, no matter what happens, at that point, it's too late. I'm sure you probably all heard of people that have been put to death and then later they have determined that they didn't do this. If we make that decision here today, if you have any lingering doubt, think of this other box here. If you have anything at all that you're just not absolutely sure, think of this other one. Because if we don't, today, this is your decision. This is the time for the decision. Now, in your decision, you have decided that Damien is guilty of these 3 counts. And you may say to yourself, yes, that's what I've decided, and yes, he needs to be punished. Well, if that's your decision, that is correct. Punishment is correct. But think of this. Is it not punishment to be in prison for life in a cell the size of a bathroom or something like that? Is that not punishment? Is that not punishment? Think of, sure, you have the right to expect justice, and that's what you all have done. And you have the right to expect some sort of punishment, and that's what you're to consider, what the punishment is. You have the right to expect protection of our society. That's certainly true. And you were charged as jurors to follow the law. Each one of those factors can be taken care of by life imprisonment, in that justice can be done, punishment can be afforded, protection of society, and you will follow the law. Don't let anybody tell you that you've got to find for the death penalty. This is your decision. It's not a have-to decision. It's your decision here today. I'm going to do this, but I think I am. I'm going to tell you a little story real quick here. It's a story where, excuse me. I didn't want to do this, I'm sorry. Okay. This is in John chapter 8. It's a story of death penalty. There's a death penalty case in the Bible here. And thinking about this, and it says, Jesus went unto the Mount of Olives, and early in the morning he came again unto the temple, and the people came unto him, and he sat down, and he taught them. And the scribes and the Pharisees brought unto him a woman taken in adultery. And then they who had set her in the midst, and they said unto him, Master, this woman was taken into adultery in the very act. Let me tell you what the scene was. They were trying to get Jesus to come in there, and they were trying to trip him up. They were trying to show him things and trying to trip him up because they knew that it was the law. It was the law, boy. If she did something, they didn't have a choice. This was the law with them, and that if they caught her in adultery, she had to be put to death. But they knew he'd been teaching grace, and so they said, well, we'll have him tripped up. What's he going to do here? They were trying to trip up Jesus is what was going on. So then, she was caught in the very act. So then they bring him in there, and they say, well, what are you going to do? What are you going to do with her? He just kind of took a stick, and it says he took that stick and he just kind of played in the ground there with it. And they were trying to tempt him. And listen to what it said here. Jesus stooped down, and in his finger he wrote in the ground as though he hurt him not. And they were wanting him to make that decision, and he finally said, okay, you without any sin among you, pick up that stone and go take care of her. You go ahead and do it. And boy, they looked at him, and he's still just kind of playing in the dirt there. And it says that they were each convicted of their own conscience. And they threw that stone down and walked away. They were convicted of their own conscience. And they put it down, and they threw it away. Now, it doesn't say what happened after this, but I wonder, can you imagine those people going home and the people saying, well, what happened? Did you put them to death? Well, no, that didn't happen. Well, she was caught in the act, wasn't she? Yeah, she was. You mean you didn't put them to death? Isn't that the law? Can you imagine the pressure that they received? I feel for y'all. Y'all are going through that same pressure, I know. But as you go back in that jury room, each one of you has that stone in your hand, and you can take it and lay it down. You've got a choice. It's not mandatory. You all can go back there if I can find my instructions. And you can look at these. You can check those off. You can consider the evidence. And I plead with you and beg with you to keep his life, to give him life imprisonment as his punishment. Thank you.
I'm going to be real brief. But remember when we were back there in voir dire, and I asked each and every one of you, under the appropriate circumstances, could you and would you consider the death penalty? And I didn't ask you, would you put somebody to death, or are you definitely against? I said, under the appropriate circumstances. And that's what Arkansas law does. It says, under an appropriate set of circumstances, the death penalty is appropriate and is authorized. And each of you said that you could consider it, and if the appropriate set of circumstances existed, then you could render a verdict returning the death penalty. I ask you when you go back there, because the aggravating factor that you must find for the state and that's listed is the cruel and depraved manner in which they were killed. And I ask you to go back there and look at that photograph of Michael Moore and look at what was done to him, and then determine if that is an appropriate circumstance to render the death penalty. And I ask you to look at the picture of Stevie Branch and look at what was done to him, the torture that that child went through, and I ask you to ask yourself, if there was ever an appropriate circumstance to return the death penalty, what would it be? Is this it? And I ask you to look what happened to Chris Byers. And if that is an appropriate circumstance, and I put to you, and it's your decision, and you're the moral judgment of this community, but I put to you that when you look at those photographs, that the injuries to those children, if there is ever an appropriate case for the death penalty in the state of Arkansas, you've got it in your hands right now. When you go back there, and they've talked about mitigating factors, and I acknowledge, I agree, you'll see a list of them, and there are some mitigating factors that you will find. You'll find they're there. And you'll make one decision. Do the mitigating factors in this case, how do they compare? And the instructions tell you what you weigh and how much you weigh, but do the aggravating factors beyond a reasonable doubt outweigh any mitigating factors that you find in each instance? And I put to you, in this case, if there ever is one, the cruel and depraved manner in which these children were killed, the age of the children that were killed, the manner in which they were killed, that there will never be a case with facts appropriate for finding that aggravating circumstance like you have here. I ask you to look at that. I know it will be a very tough decision. I want to thank you for your service here, because from the day you walked from this courtroom, and I think all the attorneys will agree, this case is going to mark everybody that's been involved with it for life. It will affect you. But I ask that you go back there, look at this, do what you told me you would do, under the appropriate circumstances, return a verdict of death. Thank you.
All right, ladies and gentlemen, you may now retire to the jury room to consider your decision and your verdicts and to make your findings.